Hello and welcome to the session in which we will discuss when is the principal is bound by the agent, and would it be possible that the agent themselves will be bound by the contract under certain circumstances. First, let's review is when the principal is bound by the agent, and we should know these from the prior sessions where we looked at what is the agency relationship, when is the principal responsible for performing. Let's review real quick. Well, if the agent has actual authority, if the agent has either express or implied authority, then the principal will be bound by the agent's action. This is a review. Also, if the agent has apparent authority, it means authority in the eyes of the third party. If there is no actual authority, but the agent has apparent authority, it means authority that the third party believes that the agent, based on the third party's dealing with the principal will be bound as well. Also, the agent could hold the principal responsible under what we call estoppel. If neither an actual nor apparent authority exists, but the principal is stopped, which is prevented from denying that there was an agency because of either intentional or careless action that caused the third party to believe there was a relationship, that there is a principal's authorized agent, the principal will be bound as well. And the third option, where the principal is bound, when the principal chooses to do what? If apparent, actual don't exist, but the principal chooses to accept the action of the agent, this is called ratification. And for each one of those, what did we do? We have a separate recording. What is ratification? If none of the above conditions apply, but the principal formally approves the contract, after the agent enter into the contract on their behalf and before the third party withdrew, the principal will be bound. So if none of these conditions are met, the principal will not be bound by the agent's act. Now the question becomes, will the agent be bound by their own act? In other words, the agent goes into a transaction, none of these apply, actual, apparent, or ratification. Would the agent be responsible? This is what we will discuss in this session. Before we proceed any further, I have a public announcement about my company, farhatlectures.com.
Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today.
Can the agent be liable to perform? Well, here's the first answer. Generally, no. If the principal is disclosed. Simply put, if there is a principal and that principal is known, is disclosed, then guess what? If there's a principal-agent relationship, the agent is acting on the behalf of the principal. In situation where the agent makes it known to a third party, known means there is a relationship with the principal, that they are acting on behalf of another party, the principal, that's it. The agent no longer have to perform, because if they are acting on behalf of the principal will have to perform. And especially we are dealing with identified means disclosed, that is known in this scenario. Under these circumstances, if the agent is operating within the authority given to them by the principal, the agent is typically not personally responsible for the contract or the agreement. They don't have to perform, they don't have to do anything, as long as they are agent of the principal and the principal is known, is disclosed. In other words, the other party is dealing with the agent under the assumption they are representing someone else, therefore the agent cannot be held to perform. Now, how about if the agent is claiming to be an agent? Simply put, they're lying. By claiming to act as an agent, there's an implicit promise from the agent to the third party that the agent had authority that they claim to possess. If it turns out later that the agent does not have authority, simply put, the agent is lying here, what they're claiming is wrong, the third party may hold the agent personally accountable for any damages that may arise due to the agent misrepresentation of this authority. Here, this is breach of implied warranty of authority. They might sue them for tort because there is some damages the person was lying. They're not even an agent. Okay? Example. An employee of the company signs a contract with a supplier to purchase material. The employee tells the supplier that they are acting on behalf of the company, the disclosed agent, and have the authority to make such purchases. Well, if the employee has the authority, then that's fine. The company is liable, not the employee. Let's change the scenario here. Let's assume the employee knows they don't have the ability. They don't have that authority. If the employee don't have the authority to make the purchase and the company refuses to honor the contract, well, the supplier could then hold the employee accountable for misrepresenting their authority to enter into a contract. Simply put, you sue them for lying, causing the supplier to potentially seek damages for this breach of this implied warranty. So here we have what we call agent's liability. Also, the agent could be liable when they enter into a third party without revealing that they are acting on behalf of someone else. Well, the other party don't know that this individual is acting on behalf of someone else, or what we called only partially disclose the principal identity. Simply put, means the third party knows an agent is acting for the principal but does not know the principal's identity, and this is referred to as unidentified or undisclosed principal, and we're going to see the difference between them shortly. Simply put, the agent is, acting as, he's not representing anyone. Then if you're dealing with that type of person, you're dealing with the, end quote, the principal themselves, because they are not representing anyone. Therefore, if they enter into a contract, they could be held liable. And if the principal is identified, not identified, or undisclosed. In this situation, the agent themselves can be held directly responsible for the contract. In cases of undisclosed or unidentified principal, the third party have the choice, because eventually they will figure out who the principal is, to either hold the principal or the agent accountable for the contract once the principal's identity became known. They cannot hold both parties liable, just one party. They can either choose the principal or the agent. Now, most of the time they are going to choose the principal, because the assumption is the principal will have deeper pocket, more resources to go after rather than the agent. Let's take a look at what we mean by not identified, unidentified principal. Suppose a real estate agent, the agent is authorized to buy property on behalf of a client, but the agent does not disclose the client's identity. So I'm telling you, I am acting on behalf of someone, but you don't know who that someone is. If the deals go sour, the seller can choose to hold either the undisclosed client or the agent responsible for any breach of contract. So I am the agent of someone else. That's what I'm assuming, but you don't know who that person is. Undisclosed principal, for example, an art dealer who buys a painting from an artist without revealing that they are person for a collector. Now, the dealer is buying, who's an agent, but they're not revealing that they are buying on behalf of someone else. Undisclosed principal. So when you are dealing with them, you're not dealing with an agent with a not identified. They're not telling you they are representing anyone. Now, if the dealer refuses to pay, the artist may sue the dealer. Now, once the collector's identity is revealed, which is the principal, the artist can choose to sue either the collector or the dealer, but not both. Same situation. The collector's undisclosed status does not change the fact that they had given the dealer the authority to purchase the art on their behalf. Just know the difference between undisclosed and unidentified principal. Now, bear in mind, when the undisclosed principal exists, there is no such thing as apparent authority, because when you are dealing with that third party, apparent authority exists when the third party assumes you have the authority. Well, when you are presenting yourself in an undisclosed principal situation, there is no principal. Therefore, there is no apparent authority. So the concept of apparent authority does not apply, because third party are not aware that the agent was acting on someone's behalf in an undisclosed principal. There is no apparent authority. Apparent authority relies on third parties understanding that the agent representing a principal. It does not exist in undisclosed principal. So that's an easy elimination in a multiple choice questions. However, the disclosure status of the principal does not affect the agent's actual authority. There's actual authority, which is the authority that the principal has explicitly or implicitly granted to the agent. We still have the actual authority because once that relationship is discovered, disclosed, that actual authority exists. In most contractual situation, here's what you need to know. The person or the entity for whom the agent is acting, the principal, is the one who has the legal standing to enforce the contract against the third party with whom the contract was made. So generally speaking, the principal is the person that can enforce the contract eventually. This holds true even if the agent did not disclose that they were acting on behalf of the principal, or if the principal identity was kept secret from the third party. Eventually, the buck starts with the principal. Example, Emily acts as an agent for Jonathan to acquire a piece of artwork from a gallery. Great. So Emily is the agent and Jonathan is the principal. Emily negotiated the deal with the gallery, but she does not mention that she's buying the artwork for Jonathan. Instead, she negotiated the deal as if she's the end owner. Here we have an undisclosed, not identified, undisclosed. She's not even disclosing that she is an agent. If the gallery owner later decides not to sell the artwork or breaches the agreement in some way or another, it's Jonathan, the principal, who has the right to seek legal recourse against the gallery owner for the breach of contract. Although the gallery owner was not aware of this relationship, was not aware that Jonathan's was Emily's principal. Emily, as an agent who did not disclose her role, would not typically have the right to enforce the contract against the gallery owners. Now, there are few exceptions that you need to be aware of to the rule that a principal can hold a third party liable. So, under those circumstances, the principal cannot hold the third party. They cannot force them to perform. Let's take a look at those exceptions. 1. When the principal intentionally concealed their identity through deceptive means. For example, one company don't like to work with another person or another company. So what does the other company does? They will hire an agent to act on their behalf. But that company, they don't want to, like they simply for one reason or another, they don't want to do that. So if that agent is undisclosed to that party, then that the principal, the party that people that don't want to deal with cannot enforce the contract. If a third party explicitly state they would not want to engage in business with a particular principal, that principal cannot then use an agent to form a contract while hiding their identity to circumvent the third party wishes. So you cannot hide an agent under those circumstances. Therefore, the principal cannot enforce the contract. Another exception is when fulfilling the contract for the undisclosed party would significantly increase the third party obligations or burden. Here is where you are going into a contract and you're not aware of the economic or need for that undisclosed principal, and under those circumstances you have no obligation to perform because you are not aware that the burden is too much. For example, you're dealing with a large company and you cannot keep up with the contract. This typically happens when the principal's identity affects the scope or the nature of the performance required under the contract, where you don't have the ability to serve this principal. You were not aware because the principal was undisclosed, and that created a burden or an obligation that we cannot fulfill. So under those two circumstances, the principal cannot hold the third party liable for the contract. And in case you get a question like this, it should be clearly stated or clearly expressed in the problem that the party cannot complete the work. Just too much of a burden. Let's take a look at this multiple choice questions from farhatlectures.com. In contract involving an undisclosed party. Undisclosed party means the agent is acting as if they are acting for themselves. The third party, what can the third party do? Must hold the agent liable. Must is a strong word. They don't. They can either hold the agent, they can, or they can hold the principal. Usually they hold the principal. B, can choose to hold either the principal or the agent liable once the principal's identity is revealed. Can they do that? Absolutely yes. When the undisclosed principal identity is not known, once it's known, The third party can ask either the agent or the principal to perform. Usually they ask the principal because the principal hired the agent. The principal will have deeper pocket. Let's make sure C and D are not correct. Can hold both? They cannot hold both. Remember, under contract law, you either have to hold the principal or the agent, not both. Be aware of this, or not both. Can't hold anyone liable once the principal is disclosed. Not at all. You have a recourse against either of them, whatever you choose. What should you do now? You want to go to Farhat Lectures, look at additional MCQs. That's going to help you prepare for your CPA exam, business law, whatever you're studying for. Invest in yourself. The CPA exam is worth it. Study hard, good luck, and stay safe.